We are now in David Ingram's um, Law, and this is Lecture 1, Part 6. In it, we're going to discuss the 14th Amendment, its 1896 meaning, its 1954 meaning, philosopher named Dworkin, who presents to us these facts about the 14th Amendment and his interpretation, and the moral core of law that Dworkin finds in his thinking about the history of the 14th Amendment. And this moral core of law turns out to be respect for the dignity of individuals. That a merely instrumental, positivist conception of law that contains, as if almost by necessity rather than by intention, only a brief minimum of morality is not adequate, and that a more substantive conception of the rule of law is needed, is demonstrated in considering the work of another contemporary philosopher, Dworkin. Ingram examines Dworkin's look at an interpretation of the history of the 14th Amendment. The 14th Amendment states and guarantees that no state shall deny to any person equal protection of the laws. In 1896, in Plessy versus Ferguson, the Supreme Court ruled that there's no conflict between racial segregation and equal protection. That decision was legally correct from the standpoint of inner morality and legal positivism, but that does not mean that it was morally correct. In 1954, in Brown versus Board of Education of Topeka, the Supreme Court ruled that racial segregation and equal protection under 14th Amendment are not compatible. Racially segregated public schools were ruled unconstitutional by Supreme Court. Racially segregated schools were concluded to deny to black children their right to an equal education. Even if the resources made available to the two types of school were equivalent, the stigma of separation and segregation is enough to undermine the learning of black students. This was a radical departure from the precedent case in 1896. Dworkin argues that the different decisions of the court are based on the moral core on which the Constitution is based, and that is a part of the Constitution. This moral core is the thicker interpretation of equality and rationality that we have seen Finnis attempt to attribute to the rule of law. In other words, according to Dworkin, the Supreme Court judges in 1954 did not bring external standards to bear on the Constitution, but rather developed and completed what was in the Constitution all along. Dworkin argues that the founding idea of the Constitution that is not explicitly stated there is moral, and it is the idea of respect for the dignity of individuals. Dworkin argues that this idea was not clear to the Supreme Court judges in 1896, but it became clear to them in 1954. It explains why it became clear that motivation but by prejudices that aim at demeaning a small group of citizens, segregation, cannot possibly be legal.